Let's begin with business and immigration law updates. This is a presentation of the Corona Law Firm located in Maryland. The moderator on this set is Attorney Kenneth Haber. Today, Attorney Haber questions Attorney Corona on F-1 student visa requirements and maintaining status. Let's join this dialogue.
Welcome. I'm Kenneth Haber. I'm a former Assistant United States Attorney and a former Senior Attorney in the Office of Inspector General of HHS, Health and Human Services. This is the Capitol Forum, and with us is Ramesh Khurana. Welcome, Ramesh.
Thank you, Ken.
Ramesh is here today to discuss on the Capitol Forum the student visa, F-1. This is a visa that is so common at all the universities because we're becoming such a multi-complex population with so many people wanting to come and visit and learn here. And it's part of the globalization process, and there's a lot, I'm sure, that we have to know about the F-1 visa, Ramesh. What are the general requirements of getting an F-1 visa?
Ken, you made a very correct statement that F-1 visa is very common, but there are certain challenges attached to obtaining F-1 visa. Every day I hear in my practice that so-and-so person was denied F-1 visa at the U.S. consulate because that person was unable to articulate some of the answers to the questions which were posed by the U.S. consulate. So, general requirements you always have to keep in view that you are admitted to a school which is approved by SAVIS, which is a student and visitor exchange program. Now, this is very important. This program has been created which has records of all the students. So, when you when you are approved, when you apply for admission to school, your record is created in the SAVIS system, and Department of Homeland Security and U.S. Consulate, they can access these records. This is internet based, web based. So, they have information whatever is input by the school official. Every school has a designated official which is called DSO. In the international department, we call DSO, designated school official, who is in charge of the SAVIS program. So, you have to meet with those requirements. The school is registered with the SAVIS, and I-120 form is issued by the school. So, how it can be issued, what kind of program do you like, and first of all, you need to be accepted by the school. So, once you have been accepted, then they start the process and you follow the steps.
Could we back up 1 second? And that is, can any school issue the 120, or do they have to be approved?
Yes. For the purpose of immigration, any school which is approved under SAVIS, if that school is issuing I-20, which is verifiable by the Department of Homeland Security or the State Department, only that school is going to be considered for the purpose of immigration.
Can a student transfer schools while he's on his F-1 visa?
Again, that has got to be approved. Yes,
but
that has got to be approved. Let's say the person or student has arrived here. He is admitted to University of Maryland. He changes his mind after 1 semester or 1 academic year. He says, I am going to move to University of Virginia. Then he is to apply. He is to apply for issuance of Form I-20 by Virginia State University, and his SAVIS records would reflect that.
And then it has to be approved again?
Yes, it has to be approved.
But it doesn't have to be approved again if he stays at Maryland? Or does he have to do it annually?
He doesn't have to do annually basically, but there are some requirements, like he has to take a full load of credits. If he is at undergrad level, he has to take minimum of 12 credits per semester. Of course, there are some exceptions, one-time exception, like if he wants to take the lower number of credits, or if this is the last semester, then whatever number of credits is left now, he is to take, even though if these happen to be lesser than 12. But otherwise, that person has to take the full load of credits. Otherwise, this may hamper that person's chances of being validly on F-1 visa. And all these records can be easily seen by Department of Homeland Security.
And does the school issue him an F-20 every year as long as he's got the full load?
You mean I-20? Yes.
I-20.
Yes. I-20 is issued by the school where the student is admitted.
So, and that goes to immigration.
Yes. And that DSO is inputting the information into the service system, because that's the only way of communication between the school and the Department of Homeland Security. Like I said, these records are also seen by the State Department or the US consulate when this person goes back to his or her country. So that is the record. School doesn't keep any paper record. All records are there in service.
Digital.
Yes. And these I-20s are issued to the student, and student has all those records. Just a note of caution to the students. If you have been issued any I-20s, please save them carefully at a safe place. When you apply for H-1B after completing your education, you have to show at what stage Form I-20 was issued to you. And there should be continuous change of I-20s. If I-120 is missing, then of course you can prove it by other evidence, but it becomes really very difficult. And school is not keeping any hard copies. They are keeping everything in service. So please be careful about your Form I-20s.
What's the first step in obtaining a F-1 visa?
So Ken, as I said, the first step is to choose your school, and you decide what you want to do. Make an application, and if you are accepted, that school will issue you Form I-20. So that is the first step.
Is it true that obtaining a F-1 status, a person must receive the I-20 in order to?
Yes, yes, that is the first step.
And the third step, in applying for a visa at the consulate, what does that involve?
Ken, when you have been issued Form I-20 and you have paid the fee required under the service system, which is called Form 901, so then you can apply for the visa at the US consulate. So you will appear in person before the US consulate along with your documentation and Form I-20. And US consulate again has an access to the service records. They can see that this person has been accepted, let's say by University of Maryland, and I-20 has been issued, he has paid the service fees, then he looks at the credentials of the person who is presenting himself before the US consulate, and if everything looks bona fide and genuine, the US consulate will stamp his passport with F-1 visa. And they want to make sure that this person doesn't have any immigrant intent. That means doesn't want to become a green card holder in the United States, because this is an F-1 visa, this is non-immigrant. And this person has to prove that this person's ties are very strong with his or her own country. He has to keep his home abroad. He's just temporarily coming to the United States to obtain education from some particular school. So if his immigrant changes, then that becomes the ground for denial of F-1 visa to such a person.
But at the same time, he can get a work visa once he's done his academic program and got his degree.
Yes, like we discussed in other sessions about H-1B visa, for example. That's a work authorization. At that point of time, H-1B visa, now this person has a dual intent. That means this person is going to work here. and maybe he is going to apply for a green card. So that is permissible under the regulation. That's not a problem.
And somebody during all that time frame could fall in love and decide to get married.
Oh, sure. You know, if that happens, then of course, looking at the intent of the person, what is the timing of getting married, and whether it's a bona fide marriage or not. So that point has got to be adjudicated by the USCIS.
Our school systems now are not school systems in terms of public, but the universities, they have where people can take classes during the summer, and they have a variety of flexibility in getting through your program. How flexible is the Immigration Service as far as permitting people to deviate from 12 credits every single semester?
Oh, that's very difficult. Like I said, the person who is on an F-1 visa has to take the full workload or credit load, and for the undergrad level, the minimum credits required are 12 credits, but there may be certain situations like your health is not permitting you, and it is well documented. The designated school official may give you a waiver, but maybe once, but otherwise second time this person is definitely is going to having a hard time. You are here as a student on a full-time basis.
But that doesn't entail summer school, does it?
You know, summer school, because whenever a person is issued an F-1 visa or student visa, this is for the duration of stay. It's called DS. There is no fixed date. So basically when he is going to complete his education, that's the way this F-1 visa is issued. So if you want to take some classes during summer, yes, he is on a valid visa, F-1 visa.
And then he could possibly take less classes the next semester because he's already made up?
You know, again, not less than 12. Then that means he's moving faster.
I see.
But whatever credits are left during the last semester, even if he is left with 4, then that's not a violation of his status.
I see. It's only at the end that he can.
Yes, yes.
That's interesting. I ran into many students when I was at the University of Michigan who were over in this country at the University of Michigan on student visas, and they all had a variety of different experiences.
Sure.
Well, I'd like to thank you very much for coming and explaining this to us. I'm sure that it's been very helpful for many of the viewers out there.
Thank you very much.
Thank
My
you.
great pleasure.
My pleasure.
Being here.
Thank you.
Again, last word to the audience. Always talk to your immigration lawyer if you have any questions. Thank you for being with us.